Good morning, everyone, and thank you for joining us today. My name is Catherine Allen, and I'm here today to talk about public sector corporate governance. I'd also like to introduce my public regulatory and investigations team partner, Aoife Moran. And as you can see from the title slide, we'll be navigating the important areas of transparency and accountability today. So just a brief overview of what we're going to talk about today. We get a lot of questions in our team about public sector corporate governance. And I think it's important at the outset to distinguish between private sector and public sector corporate governance. The same types of themes apply, of course, but our view is that quite different rules apply in the public sector. And indeed, it takes on a very special significance in the public sector. Simply put, of course, it's the systems of rules, practices, and processes that direct and control an organization, which is the same in the private sector, of course. But in the public sector, ultimately, it's about ensuring that public money, taxpayer money, is used effectively, efficiently, and ethically, and always in the public interest. And for this reason, public sector governance faces unique challenges. You're dealing with complex stakeholder relationships, political influences, and a high level of public scrutiny. Of course, in a session like this today, it's very difficult to give any detailed look at public sector corporate governance. So today, we'll explore some key principles, legal frameworks, and other critical elements that make up the landscape of public sector corporate governance in Ireland. And then we'll examine one area in particular, which is the regulation of lobbying. Next slide, please. To start with, I think it's useful to consider what's known as the Nolan principles, or the 7 principles of public life, because these principles influence a lot of the specific issues and guidance and rules and regulations that make up public sector corporate governance. And for those of you who are not familiar with them, these principles were not developed in a vacuum. They arose from a growing recognition of the need for greater clarity and stronger ethical standards in public life. And in the UK in the early 1990s, a series of scandals and concerns about standards of conduct led to the establishment of the Committee on Standards in Public Life, which was chaired by a Lord Nolan, hence the Nolan Principles. And this committee was tasked with examining ethical standards in public life and making recommendations for improvement. And their work was groundbreaking because they recognized that simply having rules and regulations wasn't enough. You also need a clear set of principles to guide behavior and promote ethical decision making. So after extensive consultation and consideration, the committee developed the 7 principles of public life, and they have since become a widely recognized and influential framework for ethical conduct in public service, not just in the UK, but internationally, including here in Ireland. And these principles are fundamental to building and maintaining public trust. And you can also see them influence the different areas of regulation that we're going to talk about later on. But just to review the principles briefly, they are selflessness, which is acting solely in the public interest; integrity, being honest and adhering to high ethical standards; objectivity, which is making decisions based on evidence and merit and not personal gain; accountability, which is being answerable for your actions and decisions; openness, being transparent about your work and decisions; honesty, being truthful and candid; and finally, leadership, which is promoting and upholding these principles. And these principles aren't just nice to haves, they are the bedrock upon which good governance is built. They inform every aspect of how public bodies should operate. So moving away from the general principles and onto the next slide, please, we can see how these principles start to become concrete in legislation. And this is the starting point for good governance for every organization, every public body. So whether it's a government department, a state agency, a local authority, or any other publicly funded organization, you will operate under a specific piece or indeed pieces of legislation. And this legislation is your foundational document. It's your foundational part of your good corporate governance. It is the rule book that sets out your powers, functions, and duties. And it's absolutely critical that public bodies not only understand their governing legislation, but also adhere to it meticulously. It isn't just a matter of ticking boxes, it's fundamental to your good governance. Compliance with your governing legislation involves several key aspects. First of all, of course, you have to have a thorough understanding of the legislation. And that means not just knowing the general principles, but understanding the specific details, the nuances, any recent amendments or any case law that might have interpreted the legislation or given a particular view as to the application of it. In addition, it's essential that to have staff members with expertise to interpret and apply the legislation correctly. Secondly, public bodies need to translate the requirements of their governing legislation into concrete policies and procedures. These policies and procedures provide practical guidance for staff. They ensure that day-to-day operations are aligned with your legal framework. So if there is a piece of some of your legislation indicates or sets out broad guidelines about how you should carry out a particular function, you then need to develop detailed policies that specify the procedures to be followed at each stage of the process of carrying out that function. Thirdly, compliance is not just a one-time event, it's an ongoing process. So you need to regularly review and update your policies and procedures to ensure that they still comply with your governing legislation. It may have been amended, or there may have been case law which might influence how you should interpret your legislation. So laws are not static, they evolve, and you must adapt accordingly. That may involve taking legal advice or consulting with experts, and also ensuring continual professional development for staff. Finally, and perhaps most importantly, all actions and decisions taken by a public body must be within the legal framework set out by its governing legislation. So this means every decision from strategic planning to day-to-day operations must be legally sound. You must be able to demonstrate that your actions are compliant with your governing legislation because, of course, non-compliance with governing legislation can have serious repercussions. It can lead to legal challenges such as judicial review or statutory appeals, and they, of course, can be costly and time-consuming to deal with. It can also severely damage your reputation and erode public trust. So compliance with your governing legislation, it's not just a legal obligation, it's a core element of good governance. And it demonstrates your commitment to accountability, transparency, and the rule of law. Next slide, please. So compliance with your legislation is a given, but it's often not possible, of course, for the board of an organization to carry out all of the functions that are specified within the governing legislation. And that's when delegation of functions comes into relevance. So public bodies very often delegate functions to staff members, committees, or even external organizations in certain circumstances. It's a common and necessary practice. And effective delegation, of course, can lead to increased efficiency. It allows for the application of specialized expertise. It frees up senior management to focus on strategic issues. However, delegation must be approached strategically and managed carefully to ensure accountability and maintain good governance. So the starting point is to have a robust framework for delegation. First and foremost, any delegation of functions must be explicitly authorized. This authority might come directly from the governing legislation of your public body, or it could come from a designated authority within the organizations, such as the board or the CEO. There must be a clear legal basis for the delegation. Secondly, the responsibilities being delegated must be clearly and unambiguously defined. Vague or poorly defined delegations can lead to confusion, overlap, gaps in responsibility. And that can be very problematic in circumstances where you are subject to judicial review, for example. It's crucial to document the specific tasks, powers, and limitations associated with each delegated function, and this documentation should be readily accessible to all relevant parties. Thirdly, the individual or committee to whom functions are being delegated must possess the necessary competence and expertise to carry them out effectively. Delegating complex financial decisions to someone without financial training, for example, would be a recipe for disaster. So you need to assess the skills and experience of potential delegates and provide appropriate training and support where needed. Fourthly, effective oversight and monitoring mechanisms must be put in place. Delegation does not mean abdication of responsibility. The public body, you remain ultimately accountable for the performance of the delegated functions. So that requires regular reporting, performance reviews, clear lines of communication between the delegator and the delegatee. It's essential to have systems in place to identify and address any issues or concerns that may arise. Finally, and crucially, accountability must be maintained. So even where functions are delegated, the ultimate accountability rests with the public body. You can't simply wash your hands of the matter. You're responsible for ensuring that the delegated functions are carried out in accordance with the legislation, policies, and your principles of the organization. So absolutely, delegation offers potential benefits. It improves efficiency by distributing workload. It allows staff to specialize. But if it's not managed effectively, it can create significant risks. It can lead to a lack of control, inconsistencies in decision making, even fraud or corruption in the worst case scenarios. Therefore, a well-defined delegation framework combined with robust oversight and monitoring is absolutely essential for good governance in the public sector. It's really about empowering your staff while maintaining accountability and safeguarding public resources. Next slide, please. So we've spoken about the specific governance structures that will apply to you under your governing legislation. But of course, as a public body, you operate within a complex web of legislation, regulations, and guidance. So it's not just about the specific laws that govern each individual public body. You have to look at the broader framework that sets the context and establishes standards for good governance across the sector. So this framework is designed to ensure many of the things that are mentioned in the Nolan principles to ensure accountability, transparency, and value for money in the use of public resources. As we've already discussed, at the most fundamental level, you operate under your own specific governing legislation. But you must look beyond that to other guidance, probably the foremost of which is the Code of Practice for the Governance of State Bodies, which provides detailed guidance and best practices for how state bodies should be governed. It sets out principles related to board composition, risk management, internal controls, financial reporting, and so on. It provides a benchmark for good governance and helps public bodies to ensure they are operating effectively and ethically. Then we have, of course, the Controller and Auditor General, which are established under the Controller and Auditor General Acts. The CNAG, as you all know, is an independent office who is responsible for auditing public finances and ensuring that public money is being used efficiently and effectively. And those CNAG reports provide valuable insights into the performance of public bodies and can highlight areas where improvements are needed. Perhaps something you might not automatically think of as part of governance are the Freedom of Information Act. But if you go back to the Nolan principles, you will see that openness is one of the principles listed. So they are, in fact, whether you like them or not, the freedom of information is crucial for promoting transparency and accountability in the public sector. Similarly, again, not perhaps something you'd immediately think of as part of governance, but the Data Protection Acts are also, and GDPR, I'm including GDPR with that, is an important part of the legal and regulatory framework for public sector governance because it tells you how you should collect, process, store, and perhaps most importantly, share personal data. Its compliance with this legislation is essential for protecting the rights of individuals and maintaining public trust, but also disclosing data and knowing when it can be disclosed and shared with other public bodies is an important part of good governance. That's just a couple of areas that I've highlighted. Of course, in addition to these key pieces of legislation, there are numerous other regulations, circulars, and guidance documents that impact public sector governance. To name just a few, you have a lot of guidance in the areas of public procurement, financial management, human resources. Oversight is provided by a range of bodies. Oireachtas committees, of course, play an important role in scrutinising the performance of public bodies and holding them to account. You also have the likes of the CNAG, as we've already mentioned, and the Public Accounts Committee. So there are various different modes of enforcement of good governance. Next slide, please. The governance landscape isn't limited to just the legislation that I have mentioned. I like to nearly think of it as a pyramid with the governing legislation of a particular public body at the top, supported underneath by the more specific pieces of legislation that I've mentioned. And then underneath that again, you've got other important pieces of legislation that play a crucial role in shaping how public bodies operate and ensuring they adhere to the highest standards of conduct and transparency. So again, you might not necessarily think of all these pieces of legislation listed on the slide as impacting on your governance, but I would suggest to you that they do. So, for example, the Regulation of Lobbying Act, which Aoife is going to talk about in a little bit more detail later on, is designed to promote transparency in the interactions between public officials and lobbyists. The Ethics in Public Office Acts and the Standards in Public Office Act set out detailed rules and standards of conduct for public officials, covering areas like conflict of interests, gifts, and donations. Protected Disclosures Act 2014, maybe not necessarily something you'd automatically think of as governance, but it is vital, again, for fostering that culture of openness and accountability. Public procurement, being the process by which you all purchase goods and services, is designed to ensure fair, transparent, and competitive processes, again, preventing corruption and ensuring value for money. Sticking with the theme of access to information, we have the access to information on the environment regulations, which again create rights in relation to information held by public bodies. There's a couple of other ones that maybe you wouldn't think of as governance, but again, I think are very important. The likes of the National Archives Act 1986 regarding preservation of records, and even indeed the Official Secrets Act 1963, which of course has to be balanced against the requirements of openness and transparency in the FOI Acts. Finally, you could even include things like the Official Languages Act, which promotes the use of Irish language in public administration, ensuring accessibility of public services to all citizens. And finally, equality and employment legislation are crucial for ensuring that public bodies operate fairly and ethically in their dealings with both the public and their own staff. So while this list isn't exhaustive, it highlights the broad range of legislation that impacts and shapes public sector governance in Ireland. I think it demonstrates that good governance is not just about a few key principles. It's about operating within a complex and dynamic legal environment. So if we could just move to the next slide, please, to mention a few key takeaways. I think it's important to realise that public sector corporate governance isn't just one or two pieces of legislation. It's a multifaceted and evolving field. But ultimately, it's not simply a matter of following rules and regulations, although these are certainly important. It's about fostering a culture under the Nolan principles of ethical behaviour, transparency and accountability at every level of the public sector. And it's about ensuring that public resources, which ultimately come from taxpayers, are used wisely and effectively to serve the public good. So good governance is not a destination, it is a journey. And it does require constant vigilance and a willingness to learn and adapt to new points of law that are being raised, or case law or other issues that are being raised. It's crucial that everyone involved in the public sector, from elected officials to public servants, understand their responsibilities in upholding good governance, because ultimately it's about building and maintaining public trust. So on that note, I'd like to hand over to my team partner, Aoife Moran, who's going to speak about one particular aspect of good governance, and that is lobbying. Thank you, Aoife.
Thank you very much, Catherine. And so we might move on to the next slide, please. So what is lobbying? Lobbying is, in very short, I suppose, hand, an attempt to influence legislators or government officials. And what the Regulation of Lobbying Act is designed to do is to ensure that lobbying is transparent. So the Act is really there to ensure that information about lobbying is made public. And that includes information about who is lobbying, who is being lobbied, on whose behalf the lobbying is carried out. So that might arise in the context of, say, a professional lobbyist who is engaged to carry out lobbying activities on behalf of someone else. Also, what are the issues involved in the lobbying, or what is the lobbying about, and what is the intended result of the lobbying? So the Act doesn't aim to prevent or inhibit lobbying in any way. What it instead does is it seeks to ensure that lobbying is transparent. And as Catherine mentioned earlier, as part of the Nolan principles, one of those is openness and transparency. So the 2015 Act aims to do this by firstly establishing a register containing lobbying activities. It aims to place obligations on lobbyists to register and then provide information which is then placed on the register about their lobbying activities. And the Act also established SIPO, which is the Standards in Public Office Commission, and that is the regulator of lobbying in Ireland. So if you move on to the next slide then, please. So, I gave a brief summary of what lobbying is at the very start, but I suppose it's a little bit more detailed, unfortunately. So not all communications to public service bodies can be lobbying. So there's a certain amount of ingredients that need to be present for the Act to kick in. And it's important for designated public officials, or DPOs, as they're also known, in public service bodies to recognise when they are being lobbied. And I'm sure we've a number of DPOs here with us today. So let's look at the definition of lobbying activity that's contained in the Act. So as I said, it has quite a few different elements, so I'll run through them. The first is that the activity must be an oral or written communication. So that's relatively straightforward, but the thing to remember is that that also includes social media communication. So if you're communicated to via X or Instagram or Facebook, that could constitute lobbying. It's also, the second point is that the lobbying activity must be made on behalf of certain individuals or organizations, by or on behalf of certain individuals or organizations. Now, the definition of organization is very complicated. I'm not going to get into it today, but in summary, what it includes is entities with more than 10 full-time employees, or interest or issues-based groups, or third-party lobbyists. Thirdly, the lobbying must be by a designated public, must be to a designated public official. So if you're not sure if you are a DPO, very helpfully, SIPO has a list of all DPOs on their website, which is www.lobbying.ie. Fourthly, the lobbying may be direct, but it can also be indirect. So an example of that might be if you were, instead of lobbying directly to a DPO, what someone might do is ask a colleague of that DPO. They might lobby directly to them and then say, listen, will you pass that on to the DPO? So that's an example of indirect lobbying. The communication is not directly to the DPO, it's to a colleague in the same organization as the DPO. And then finally, the activity or the lobbying activity must be about a relevant matter. And so you may ask, well, what is a relevant matter? And I'm going to address it in the next slide. So you might move on to the next slide, please. So relevant matters are described under 3 headings, and I'll run through them now. The first is initiation, development, or modification, as opposed to implementation of a public policy, program, or piece of legislation. So in this instance, a lobbyist might approach a DPO seeking to modify a piece of legislation. They may say, listen, this legislation should be changed to do this, or, it can be altered in some way. And it's important that that approach to the DPO asking for the legislation to be changed or be implemented, it's important that that is transparently done. However, if the legislation is already in place and the approach to the DPO is, say, listen, I don't really understand how how this legislation affects me. How is it implemented? How is it properly implemented? That wouldn't be captured by lobbying, because that's the implementation of the legislation as opposed to any sort of change you might want to make to the legislation. Secondly, then, relevant matter includes the award of any grant, loan, contract, or license or authorization involving public funds. So here you can see the importance of transparency around the use of public funds and any activities that are seeking to influence how public funds are used. And the third then relevant matter, which is considered lobbying, is zoning or development of land. So obviously activities around zoning and development may have significant financial consequences, and it's very important that there is transparency around any activities relating to this. So if we move on to the next slide then, please. So these are all, I suppose, what I've just described are activities that constitute lobbying, but I suppose that could also capture a lot of activities that the Act doesn't necessarily want to capture, and they are known as accepted communications. Now, there are 16 in total, and they are set out in section 5, subsection 5 of the Act. I'm not going to go through them all, but if you want to look at them, that's where they are, but I'll touch on a few of them. So the first is private affairs of an individual. So that is not lobbying. So if you contact a DPO about your private affairs, that is not lobbying, unless, and there is always an exemption to the exception, unless that, that discussion relates to zoning or development of land. Next is factual information. And then thirdly is diplomatic relations. So these are all accepted communications. They do not constitute lobbying. Any communications by a DPO in their capacity as a DPO. And I suppose the reason why this is an accepted communication is because it's expected that DPOs, who tend to be CEOs, special advisors, ministers, they will do a certain amount of lobbying as part of their role. So that is an accepted communication. Next is communications between public servants, and importantly, the caveat there is that it must relate to the functions of the public service body. And then finally, we have public consultations, but only where the submissions will be published. So an example of that might be if there's, if we're proposing, or the government is proposing to update FOI legislation, they may ask people to make submissions in relation to amendments. And so long as those submissions are published, there's no need to make a lobbying return in respect of those communications. So if you move on to the next slide then, please. So you may ask, well, what is a designated public official? How do I know if I'm captured? And this slide just illustrates all of the DPOs that were captured by virtue of the coming into force of the Regulation of Lobbying Act on the 1st of September 2015. So automatically government ministers and ministers of state are DPOs, TDs and senators, MEPs, members of local authorities, special advisors, secretary generals and assistant secgens in the civil service, and CEOs and directors of services in local authorities. So they are all DPOs. Now, since the coming into force of the legislation, there's been a number of statutory instruments they have expanded the pool of DPOs. And the most recent expansion, so to speak, has came into effect on the 1st of January of this year. And that statutory instrument included 60 additional roles from 30 public service bodies, and they designated those roles as DPOs under the Act. So if we move on to the next slide, I've just included a sample of some of the bodies that were affected by that recent statutory instrument. So moving on to the next slide then again, so you may say, right, okay, I'm a DPO, or I'm a newly appointed DPO. What are my obligations? And I'm going to run through those now. And I suppose for the DPOs who have been DPOs for a long time, there's no harm in a bit of a refresher of what your obligations are. So I'll give a brief recap. The first is to self-identify. It's always good practice to self-identify as a DPO if you're at meetings, on emails, or if you have a business card, to have it there on your business card. So people who are lobbying you or discussing matters with you, they know that you're a DPO, and they need to make sure, they need to check whether they need to make a lobbying return in respect of that communication. Secondly, it's important to maintain records. So of any lobbying communications with you, that you maintain records of those. And this will become clear as to why shortly. Thirdly, check the register. Expect that as a DPO, your name will appear on the lobbying register as a result of any lobbying communication. But in checking the register, you have an opportunity to correct any incorrect information relating to you on the register. Now, it is important, I suppose, SIPO will look or may look for evidence to demonstrate how the information that's posted is incorrect. And this is why it's so important to maintain records of any lobbying to you. Do refer to SIPO's website. And also refer any lobbyists to SIPO's website. It is a really fantastic resource, very easily digestible codes of conduct, guidance, documents for lobbyists and for DPOs. Next, be aware of the Act, the guidelines, and the Code of Conduct. And as I said, they're all available on SIPO's website. And in particular, when you're referring to lobbyists to the website, this is very helpful to them in that they will then know what's expected of them when they are lobbying. Next, remember that lobbying is a legitimate and valid part of your role, meeting lobbyists is a legitimate and valid part of your role, but it's really important that such activities are carried out in an open and transparent way. So don't be afraid of it, but just know the rules around it. And then finally, I suppose, check, if you are a DPO, check if any working groups that you participate in should operate under the Transparency Code. And this is an important thing to think about, and it'll become clear shortly. So if you move on to the next slide, please, Carolina. So the Transparency Code will be more familiar with public bodies that already have DPOs, but for any public bodies that only recently had DPOs appointed, it will be important to be aware of how the Transparency Code works. So essentially what the Act does is it recognises that it's a very important element of public policy formation that people outside of the public service and people with specific expertise and skills are available to ministers and public bodies. And those skills are available to those ministers and public bodies. And so what public bodies often do is they set up a task force or a working group to focus on a particular issue or a piece of legislation. And what they'll then do is report back to the public body or the government department on any changes that might be needed to the legislation or the particular piece of public policy. And assuming that that task force contains a DPO, I suppose you can imagine how cumbersome it would be that if any lobbying is taking place in the context of meetings of those relevant working groups, that you would have, the lobbyist would then have to make a return in respect of each of those activities. So that would be, I suppose, unworkable. So the Act recognizes that, and that's where the Transparency Code kicks in and can be availed of by those working groups. So in summary, what the Transparency Code requires so that you can avail of it is, firstly, that the working group or relevant body, as it's described in the Act, must be set up by a government department or a public service body. Secondly, it must have at least one DPO and at least one member who is not a public servant. And then thirdly, the role or remit of the group must be to assess or analyse an issue of public policy or a piece of legislation with a view to then reporting back to the public service body or minister that established it. So if we move on to the next slide, then we'll look at what the Transparency Code requires you to do in order to avail of it. So it requires unsurprisingly, it requires several pieces of information to be published. So firstly, it requires the name of the chairperson and any members of the working group, together with details of their organisation, their employing organisation. If the chairperson, for example, is a member, if the chairperson or a member is representing a group of stakeholders, this should be stated in the published information. And so next, you must publish whether any non-public servant members were previously designated DPOs. So that could arise where there's an external or non-public servant who was previously a DPO of another public body. And I suppose that's relevant in the context of any influence that they may have, and also in respect of cooling off periods, which I'll get onto in a little while. Next, it's required to publish the terms of reference of the group, together with the agenda and the minutes of each meeting of the working group. Also, the expected time frame for the group to conclude its work must be published, and also any reporting arrangements in respect of the group. There's also a requirement for the chairperson to ensure that the group is operating in compliance with the transparency code, its terms of reference, and the public interest. And it's also important, if the group is publishing any final or annual report, that it includes a statement confirming that the group has acted in compliance with the code. And I suppose the downside of not complying with the code, as I said earlier, is that any communications made with the DPO then as part of the work of that working group may be regarded as lobbying activities, and a lobbying return will need to be filed. Some additional points to note that SIPO has drawn attention to is that it would like that all of this information is displayed in a prominent spot on the public bodies or the government department's website, which is easily accessible by the public. And it also recommends timeliness in publishing any updates to the information. So this should be done at least every 4 months. So moving on then to the next slide, and other publication obligations that the Act places on public service bodies and government departments. So Section 6.4 of the Act requires the public service bodies that have DPOs publish an up-to-date list of their DPOs, and that information must contain the name and the relevant grade of the DPO, and a brief description of the role and responsibilities of each of the DPOs. And I suppose this list serves a number of purposes. It allows members of the public to identify those who are DPOs, and it also acts as a resource for lobbyists submitting a return on the lobbying register. It also enables the Commission to ensure that if a return is made to it in respect of lobbying, that it is in fact lobbying, that that the communication has been made with someone who is in fact a DPO. And specifically, the Commission has asked public service bodies and bodies that are affected by the Act with DPOs to take certain steps in respect of publication. So it is recommended that a dedicated regulation of lobbying page be created on the website, similar to the FOI and AIE pages, that of course publish any details about relevant bodies, working groups, and how they operate. In relation to each of the relevant bodies, to publish information that is required by the Transparency Code, and importantly, to nominate a liaison person or an individual who will be responsible for maintaining the page, but also acting as a liaison between SIPO and the body itself. So if we move on then to the next slide, and to cooling off periods. So I mentioned this a little bit earlier. So what the Act requires is that certain DPOs, and they're entitled relevant DPOs, are defined as relevant DPOs in the Act, they are restricted from being engaged in lobbying in circumstances for a year after they leave employment or office. And what that's called is the cooling off period. So essentially, they're subject to a cooling off period in respect of particular lobbying activities for a year after they leave their role within the organization and leave their role as a DPO. It's important to note that not all DPOs are covered by this provision, so it's important to know whether it applies to you. And what it does, it requires those public officials who are covered not to carry out any lobbying activities or be employed by or provide services to a person carrying out lobbying activities in certain circumstances. And I suppose the purpose of this requirement is to avoid any conflicts of interest down the line, and in particular to avoid any conflicts of interest between public and private sector organisations. And I suppose one thing to note is that relevant DPOs who are affected, they can apply to the Commission for consent to engage in lobbying, and the Commission may decide to give consent unconditionally or subject to conditions, or they may refuse the application altogether, and that decision can be appealed. So it's not the end of the road. But I suppose if you breach the cooling off period, you can be subject to quite stringent administrative sanctions. And if you move on to the next slide, please, Carolina will see what they are. So a contravention of the cooling off period is quite serious. And since the 1st of June of last year, a failure to seek a waiver of the cooling off period or breach of it may result in any of these sanctions that are on this slide. So advice, caution, or reprimand are the more minor sanctions, and the major sanctions are a fine up to €25,000 and a prohibition from registering and carrying out any lobbying activities for up to 2 years. So those administrative sanctions have only recently kicked in, but it's most likely that we will see investigations by SIPO in respect of those. So if you move on to the next slide then, please. So I suppose it's helpful for DPOs in the room to be able to identify lobbyists. So these are the types of organizations that are most typically lobbyists. So there's commercial organizations, obviously. They may approach a public sector body in respect of a particular piece of legislation or a policy change that they may want. Representative organizations or issue-based advocacy groups most often or very frequently conduct lobbying. Persons communicating about developments or zoning of land, and obviously this is very relevant in the context of local authorities and city and county councils. And then, of course, there's professional lobbyists. I mean, law firms often lobby on behalf of their clients as well. So if you move on to the next slide then, and what I propose to do here is just to run through with you what the code of conduct is for lobbyists. And I suppose that's important in the context of if you are a DPO, knowing how a lobbyist should and shouldn't behave if they're communicating with you. And so I'll just run through each of the principles briefly. There are 7 in total. So the first is to demonstrate respect for public bodies. And I suppose it's important that a person that's carrying on lobbying activities, if they're lobbying you, they shouldn't act in a manner that shows any disrespect for the democratic process, for the institutions, for the public body itself, and they should avoid, and you shouldn't feel like they are kind of exerting undue pressure or influence on you. They're required to act with honesty and integrity. So the code requires that lobbyists don't seek to obtain information or influence decisions dishonestly or by improper means. And under the code, lobbyists should not knowingly make any misleading or exaggerated claims to elected officials. Ensuring the accuracy of information. So lobbyists are required to satisfy themselves that the information that they're providing in the context of lobbying is accurate and that it's factual and that it's up to date. Now, that being said, DPO should never blindly accept what is being said to them as truth. You should always do your own checks, but there is an onus on lobbyists to be honest and truthful. Next, disclosing of identity and purpose of lobbying activities to public bodies and elected or appointed officials. So the spirit of the legislation encourages transparency. So anonymous lobbying is not permitted under the code. Lobbyists are encouraged, and they should always identify themselves by their name, the body they work for. They should inform the DPO of any personal interest they may have in the particular matter that they are lobbying about. And they should also make it clear what the intended results of their lobbying are. And of course, if they don't do any of these things, you are entitled to press them on these issues, so don't be afraid to do so. Preserving confidentiality. So lobbyists should only use and disclose confidential information that they receive from a public body or a DPO in the context of lobbying in the manner that's agreed and consistent with the rationale on which it was shared. So I suppose that on the other side of that, DPO should always err on the side of caution in sharing any confidential information, ensure that you're not breaching any professional secrecy codes or data protection legislation, as Catherine pointed out earlier. Next, avoid improper influence. So the code stipulates that lobbyists should not seek to create a sense of obligation by making offers of gifts or hospitality. And of course, you'll all be aware of the rules around accepting such gifts. So just be mindful of that as well. And then finally, have regard to the code of conduct. Like, be aware of it. Hopefully you are after this slide. But you shouldn't feel like, you're being improperly imposed on by a lobbyist. I suppose the downside of the code is that it's not binding. But it is indicative of the spirit and the nature of the legislation, and hopefully being familiar with it will empower you as DPOs to push back if you feel that the code is not being respected. So I suppose that's my whistle-stop tour of the Regulation of Lobbying Act today. I hope that you found it useful, and obviously we're very happy to take any questions that you may have now in the chat function or in the chat function.
Thanks very much, Aoife. That was really interesting. I suppose I can see we have some great questions, but if you don't mind, I'm going to get in there first and ask if there are any key takeaways you might have for the DPOs attending here today.
Yeah, I suppose the main things for me are to obviously be familiar with the Act and the guidance. So, as I said, SIPO is an amazing resource, their website, so definitely have a look at that. It's in terms of record keeping, I think that's a key takeaway in terms of keeping records of lobbying. And that's obviously very useful in terms of if you need to correct any lobbying returns that are made. Adhere to the cooling off periods. As I said, a breach of those can be very serious and have serious repercussions. We've seen obviously issues in relation to that in the media. And I'd say don't be afraid of it. Continue to engage in an open and transparent way with lobbyists. It's a legitimate and valid part of your role. So, embrace it.
Great, thanks, Aoife. Well, I've had a look at some of the questions here, and I can see one here that you might like to take first, which is if you're being lobbied as a civil or a public servant, but you are not a DPO, what are your statutory responsibilities, if any?
Yeah, so I think that, well, I suppose you need to ensure that so I suppose you don't have the obligations that I outlined in respect of a DPO, but I suppose you probably need to make it clear to the individual that you are not a DPO, and I suppose ascertain from them why they are making the approach to you, in terms of, are they trying to, as I said, it might be an indirect attempt at lobbying. So are they seeking to maybe influence a DPO indirectly via you? So I suppose that's important to bear in mind. I'm not sure if you have any thoughts or any further thoughts on that.
Yeah, I think that, I mean, fundamentally, if you're not a DPO, you don't have any obligations under the legislation, unless it's indirect lobbying, but that's really more a matter for the person that's lobbying you. So
Exactly.
I think the key thing is the starting point that you made at the point in your presentation, Aoife, that the starting point is to identify whether you are a DPO, and all if you're not a DPO, then the responsibilities in the legislation don't really apply. So that's very helpful, Aoife. Thank you. Just turning to some of the other questions, I think this is an interesting one. Is there an obligation, do you think, on a DPO to advise or notify a person lobbying that they, the lobbyist, have an obligation to register? And I wonder, is there a distinction there, Aoife, between an obligation and perhaps
Yeah.
what you were saying about maybe alerting people to the
Exactly.
fact that you're a DPO? What do you think?
Exactly. There's no specific obligation on DPOs, a legal requirement to notify the lobbyist that they need to make a return. The obligation is there on the lobbyist to make that return. And those returns, there are, and there have been instances of fines levied on lobbyists who haven't made a return when they should. So to answer the question, there is no legal obligation on the DPO to notify the lobbyists that they need to make a return, but at the same time, the guidance that SIPO has issued and the various codes of conduct do recommend that you do that.
Thanks, Aoife. Now, there's a couple of technical ones here that are probably relevant. They're both submitted by anonymous attendees, so I wonder whether we should apply the code and suggest that perhaps any questions might come from identified attendees. But in any event, the first question is whether lobbying a publicly funded if a publicly funded entity speaks to a DPO on funding that is due to the entity, would that be considered lobbying? I think this always has to come back to the definition of relevant matter. Isn't that right, Aoife, and the exceptions to that? What do you
Yeah,
think?
so that's the first question there.
Yes. Mm-hmm.
Re-lobbying, if a publicly funded entity speaks to a DPO on funding that is due to the entity. Yeah, so I suppose it really is, is it in relation to the implementation of a policy or a piece of legislation that's already there, which might entitle you to the funding? So if it's already in place and you are saying, listen, this is due to us, the legislation is already there that makes it clear that it is, that is not lobbying. That's only that. But if you are saying, listen, this legislation or this policy needs to be changed so that we receive funding, that is very much lobbying, and that would need to be the subject of a return.
I think as well in the definition of relevant matter, Aoife, there is awards of public contracts as well. So again, if you've been awarded a public contract or you're in receipt of a public contract and you're simply trying to deal with the implementation of that public contract and your funding under that contract, that's an implementation piece. But clearly, if you are lobbying an organization in order to be awarded a public contract, that's a different scenario. I think the next question is something along the same lines, or perhaps it's a comment. So award of public funds is a relevant matter. Yeah, we've just noted that. If a state, company or semi-state is funded by the state, presumably any communications regarding funding to the relevant department is covered by the exemption ordinary course of business. What is the position if you have a general ask to other ministers along the lines of we would welcome any support you can give, and if more funding becomes available, we would welcome same. My thought, Aoife, is that this is probably a lot depends on the specifics, but there could be the accepted communication for communications in relation to the public body itself is probably quite relevant here, I would have thought.
Exactly, yeah. I suppose the important piece would be if it's part of your functions, that it may well be an accepted, communication, which would fall to be exempt. Then it wouldn't be a lobbying activity. But I suppose a lot would depend on the context as well.
Okay. Just the interesting query there at the end, are there any guidelines when a DPO gives useful information and has not been influenced by the lobbyist? I think it's important that to note that the legislation doesn't actually take into account whether the DPO has been influenced by the lobbying or not. That is actually entirely irrelevant to the question of whether you have been lobbied and whether a return should have been made. You may have found the information that you've been given to be very useful and you'd like to implement it, or you may have found it completely unhelpful. And likewise, you may have given out helpful or unhelpful information, but none of that determines whether it's a lobbying or not. You have to go back to the test, which Aoife has set out in her slides regarding whether something is a relevant matter and then whether there are any exceptions that apply. Aoife, any comments on that?
Yeah, I agree with that. And I suppose the other thing to note is that, as we said earlier, the obligation is on the lobbyist to make the return. So I suppose from that perspective, you don't need to be too concerned, so long as they make the return. And I suppose, but also, as I said, do review returns, because your names will appear, and just make sure that the manner in which the lobbying that took place, the manner in which it's described, that it is accurate.
Great, thanks, Aoife. Just there's a query there in relation to in what circumstances might a waiver of the cooling off period be sought. That seems to me to be quite a specific question, and a lot would depend on the scenario itself. Would that be your view?
That's right. I think that's right. And obviously it's ultimately a matter for SIPO. Maybe I could be correct on this, but I don't think there's a huge amount of, I suppose, kind of precedent out there in respect of it. But ultimately, I mean, as long as you can give good supporting reasons as to why the cooling off period should be waived, like if you can demonstrate that there would be no conflict per se in you carrying out this particular the lobbying activities that you want to carry out, that I think would be persuasive to SIPO, because obviously the cooling off period is really there to avoid conflicts of interest. They're there to avoid a DPO moving on from their role as a DPO within an organization and then going back lobbying that organization and likely having maybe undue influence due to the fact that that they're very familiar with all of the DPOs within the organization that they worked with them previously. So I suppose if you bear that in mind, you can, I suppose, and maybe distill some good reasons as to why that situation could be avoided in applying for a waiver.
Thanks, Aoife. I think the delegates here today were much more interested in your presentation than mine because you got all the questions. I've just got one on delegation of functions, and I'm not going to get into the detail of it because we only have a couple of minutes left, but it's really important. I think it draws out the issue that it's really important when delegating functions that you go back to the specifics of your governing legislation and what sort of delegation that permits, because any delegation will only be permissible to the extent that it is permitted by your governing legislation, and it's really important to know that and to understand that. So I hope that's helpful. It looks like we've dealt with all of our questions for today. So all it remains for me to say is, first of all, thank you very much to Aoife for her fantastic presentation on regulation of lobbying. I certainly learned a lot, and I hope you did too. And secondly, thank you to all of you for attending. We really appreciate it. We also really appreciate your feedback. So please do fill in the survey. There's also an opportunity to suggest what other topics you'd like us to cover. We're really interested in public sector corporate governance. So if you have topics and questions and things you'd like us to cover in that area, please do let us know. So that's it. Thank you very much to everyone for attending, and we'll see you next time.